Oh, hi Carla, this is Pacey and I'm agent 9241.
Hello, my name is Natalie Chin and I'm agent 9565.
Agent 640. Name? Classified.
Hi Carla, I'm an agent 8326. My name is Natalie Leaw. I'll be here to assist you today.
Hi, my name is Kheng Sid, agent code 7006.
First, let's get the facts straight. First, you have paid periodical rent, yeah? Secondly, there's an exclusive access clause that your landlord has put into the agreement. Is that right? Yeah, I guess so. Well, me and my agent would use all this information to consider both positions that you have. And if you want to take an action, it's best that that agreement is considered a lease, alright? Anyway, peace out.
Following what Agent 7640 had said, I will be explaining what a lease and a license is. They are both types of a contractual agreement where both involve using and occupying the premises in a certain way where the contract binds both parties to the term of the agreement. Even though both may seem similar, however, it is of fundamental difference in the sense that a license is a personal right, which is merely a right to occupy and does not bind third parties, which is provided by the case Lloyd and Duckton. An example of a license agreement is such as the situation of co-working spaces. On the other hand, a lease creates an interest in land which cannot be revoked and is binding on subsequent owner. A person with a lease has more protection compared to someone with a license, as a licensee enjoy a narrow rights which is provided in the case of Manchester Airport and Dumpton case. You must be wondering, why am I explaining the differences? It's important to distinguish because owners would often include terms that would negate the granting of lease to escape from its obligations under statutory provisions such as of Rent Act 1977, Housing Act 1988, Landlord and Tenant Act 1954. Therefore, how do one determine a lease? Even though the definition of lease is provided in Section 205, Clause 26, LPA 1925, however, Lord Temperament judgment in Street and Mumford case is more often referred to when in determining a lease, where in the case the court looked past the label of license which is claimed by Mr. Street, and court held that the agreement was actually a lease as all the requirements are satisfied. So what are the requirements laid down? First is the exclusive possession of land. Second is the period of time which is certain. And third is the payment of the rent. Therefore, all these three criteria have to be satisfied. If not, it constitutes merely a license. With this, strict case has reduced the landlord argument in claiming that an occupier has a license rather than a lease, and has reduced the number of occasions the higher courts to consider the lease or license issue. Even though strict case has viewed that the parties' intentions and substance of fact should be considered, however, the distinction between a lease and a license, particularly in relation to residential property, still continues to take up the time and attention of the court. One has to note that there are exceptional circumstances where there is no lease, even though these criteria are present. This will be explained by Agent 7640.
Alright, Ms. Carlisle, I believe my colleague Agent 9241 has briefed you on the distinction between license and lease. And obviously, if you want to take an action in court, having a lease is the strongest argument you can have. So my job here is to brief you on the exceptions where there are some factors that would allow the courts to consider the agreement a mere license. Alright, it's a strong factor that would make an agreement more of a license than a lease. So the first broad category we'll consider is the lack of intention to create legal relations. And in the case of Jones and Paterbatten, Cobbs and Lane, these cases show that in an event when agreement is made under a domestic or social context, the courts have a presumption that it has no intention to create legal relations, and thus the agreement is a mere license at best. Alright, the second broad category that we're going to consider would be the capacity factor. The first being mental capacity, and the second being legal capacity. In terms of mental capacity, the case of Hart and O'Connor would suggest that an agreement made if the landlord was mentally incapacitated, the agreement would not be a valid one, and thus it would be a lease at best. Alright, so in your case, we would have to consider whether the landlord, Carlito, was a relative, a friend perhaps, and if he was, there's a presumption that that agreement is a mere license. And we also have to consider his mental capacity and legal capacity in terms of whether he has the title to lease out the property. Alright, so these two factors would contribute vastly to the court's consideration of whether the agreement is a lease or a license. And if there's any of these factors that you have, then you have a weaker case. Alright. Furthermore, in terms of exceptions, we have to consider a case of Gray and Taylor. If Carlito had in his agreement stipulated a requirement that you need to fulfill before he can rent the property to you, and in any point in time you fail to satisfy that requirement, then that agreement is more likely a license than a lease. Okay, further factors you have to consider for your agreement between Carlito and yourself is whether it is a service occupancy and that Carlito, being the landlord, has provided service to you, and the second would be whether Carlito is your employer in which he provided that property for you to stay that is related or at least attached to your job so that you can do your job better. And if this is the case, then perhaps there's a stronger argument for the agreement to be a mere license. Now we're going to move on to the part on formalities. Alright, as the agreement you have shown us is unclear whether it's a deed or a mere contract, we would have to consider three scenarios. The first being the period of the duration of rent. If it is less than 3 years, then it's all good and simple. We just have to pay Carlito the best price in rent without Carlito suffering a fine, and that will be considered a legal lease operatable in law. Alright. Now, if the renting period is from 3 to 7 years, then we would have to make the agreement in deed. Alright. A deed is a special kind of agreement in which there need not be consideration, nor do we have to have two parties, but it's a stronger and more secure form of agreement. Now, this is under the Law of Property Act, section 52. Alright, sub 2. Now, if the period of rent is more than 7 years, you would have to further register the deed under the Law Registration Act 2002, section 72, sub 2BI. Alright, so these are the requirements that you have to have, and although there's a trend shifting towards electronic forms, and that would probably render these requirements redundant, but for your case in this point in time, it is crucial that you have fulfilled these formalities. And if you haven't, it's okay, all is not lost. We still have such doctrine of anticipation as laid down in the case of Walsh and Dunsdale. Alright, these would lay down the requirements for you to fulfill in order for a lease not operatable in law to be considered an equitable lease. Alright, this is very simple, which is not quite related to your case, but if Carlito plans to sell his property to Franklin and you want to exert your right as the leasee, then you would have to also register that that equitable right in the form of an equitable lease to exert your right from stopping Carlito in selling his land or property to Franklin. Alright, but as far as this case is concerned, equitable lease is not quite relevant. Okay, now I'll pass the time to the next agent to explain to you and to apply the law and explain to you if your lease was a license and what kind of rights do you have. Alright?
To determine whether the agreement between you and Carlito is a lease, you will have to satisfy the 3 requirements laid out by Lord Temperament in the case of Street and Mountford. The first requirement is the right to exclusive possession of land. To satisfy this requirement, you will have to show that you possess the land as if you were the absolute owner of the property. In the agreement, it was mentioned that Carlito is allowed to have unrestricted access to anyone. This would indicate that you do not have exclusive possession of land and hence do not fulfill the first criteria. Nevertheless, it is important to show that there is no sham agreement or labelling issues. In the case of Bankway Properties and Pensford Dunsford, it is seen that the courts are certainly concerned with preventing the exploitation by dishonest landlords or vulnerable tenants by use of such terms such as license agreement. Therefore, you can invoke the doctrines of sham or pretense to show that the outward agreement between you and Carlito does not represent the true intentions. A sham is essentially where saying one thing but doing another, whereas a pretense is where there is no genuine intention to implement the agreement where it stands. Where the court finds such a term, it can render the term unenforceable, null, and void. The case of Duke and Wine involved an agreement between the parties to which a reservation was included in the terms to allow the landlord to enter the premises at any time. However, the evidence submitted that there was no genuine intention from the landlord to make such an arrangement, and he never in fact did so. The House of Lords set aside the landlord's order for possession and regarded the defendants as tenants. Assuming that Carlito has never exercised his right to allow unrestricted access to anyone, you can argue that you have exclusive possession to the land. Furthermore, in Duke and Wine, the defendants occupied the whole premises as a matrimonial home together with their 2 sons. The court provided that it would be impracticable and unreasonable to seek to prevent the defendant's de facto occupation of the premises, as there was no other occupant. Assuming that you have a child, you can argue that you occupied the whole premises as a matrimonial home, hence satisfying the first requirement. As for the second criteria of Street and Mountford, there has to be a specific duration of the lease. Certainty of the term is fundamental, where there has to be a fixed period defined by numerical value. This was confirmed in cases Lease and Chandler, as well as Prudential Assurance, where it was made clear that a start and end date has to be specified on the deed. Assuming that in the agreement between you and Carlito, there's a specific duration written, then you would satisfy the second requirement and will be able to continue the argument that you occupied the premises as a lessee. Now I will pass the floor over to Agent A326 to talk about the third requirement of Street and Mountford, as well as legal and equitable leases.
Hi Carla. So generally a rent will be payable and rent need not be sufficient, and it could be in other form rather than just monetary form. And the rent must be given on a particular date. and the lease would be implied where it was not expressly included. And it was held in one of our hallmarks case, which is in Street and Montfort, where Lord Temperament mentions that he actually included rent as part of the definition of a tenancy. However, the existence of a lease does not actually depend on the payment of rent. I know that some people might be confused and think that laymen will think that, oh, when I pay a rent, that means I actually have a lease. That's not the case, and this has been debated in Ashburn's case and also in Westminster case. However, it was then decided in Bruton and London and Quadrant Housing Trust 1999, where it stated that the rent is not necessary for the creation of a tenancy. However, rent in practice will be payable, and this is in accordance with Law of Property Act 1925 Section 205. Moreover, although the landlord can deliberately exclude the rent obligation and still create a lease, however, an explicit exclusion of rent may suggest that both parties are not intended to create a lease, and this will depend on the facts of each case, but the absence of a rent obligation, if not counteracted by the existence of any other hallmarks of a lease, can indicate that no landlord and tenant relationship was intended. And in the case of Boston and Bryan, the obligation of to pay fluctuating utility bills such as water bill, electricity bill, gas bill, this could be seen that this could not amount to rent because it's not certain. So applying back to your case, Carla, as what you have told me before, you mentioned that you have been paying rent on a certain date, and assuming that you're paying a certain amount of rent and on a particular date, therefore it could be seen that you are a lessee and not just a licensee. Moving on, we'll be talking about legal lease and equitable lease. So what is the difference of legal lease and equitable lease, you may ask that. And a lease is a legally binding agreement between landlord and tenant, which is you and your landlord. And the creation of a lease may amount to both a contract between them and the creation of a proprietary right that exists beyond the mere contract. So in a legal lease, you definitely have more rights, and you're protected by the law. Whereas in equitable lease, you're also protected by the law, but as comparison, it's not as much as legal. So under Section 2 LPMPA 1984, where there's a contract more than 3 years lease, execute a lease which nevertheless falls short of a deed. For example, if there's a written contract but not a deed, the parties may be taken to have created an equitable lease. And the contract, there are 2 requirements that has to be fulfilled in order for you to get your rights under equitable lease, which is, first, the contract must be in writing, containing all of the terms signed by both parties in line with Section 2, Law of Property Act 1989. And secondly, the remedy of specific performance must be available for you, which is stated in Cosworth and Johnson 1886, with requirement in Walsh and Lansdale. And there are 3 requirements in Walsh and Lansdale, which is, first, there is a valuable consideration, which is what I have mentioned just now, which is the rent, or maybe not by monetary form, but it's something that can be considered as rent. Secondly, if damages would be an inadequate remedy, which means if damages is not enough for you to cover this case, or for you to claim, then or it's not the best solution for you, then you may bring up equitable lease. You may bring it to specific performance. And thirdly, you must come with clean hands in order for the court to grant you specific performance.
Hi Carla, my fellow agents, Agent 9565 and Agent 8326, have given us the criteria needed for an agreement to become a lease. In a situation where one of the criteria are not met, the agreement will only constitute as a license. First, we will look into the 3 main criteria of a lease, and also in what situation where the criteria are not met and the agreement is only a license. In your agreement with Carlito, if there is no fixed maximum period or no commencement date, it will not amount to a lease. In another situation, where it will not amount to a lease is when the tenancy is defined by an event. Assuming if your agreement contains one of these provisions, it will only amount to a license. Also, an exclusive possession by the tenant is necessary for an agreement to become a lease. In the agreement, there is an unlimited access clause. If in the past, Carlito has used this clause in a way that doesn't include the gardener or the electrician, for example, allowing somebody to come in the house and stay for the night without the permission of you, then it shows that you do not have exclusive possession. In another way that Carlito may use to negate your exclusive possession is by retaining the keys to the house. However, it is not certain because it is more important to find the intentions of you and Carlito, and it is a question of fact. Regarding rent, you have said to have paid rent every single month. If the situation is that the lease is less than 3 years, the lease does not have to be registered or have a deed, but the rent must be paid at market value. In this agreement, if you have paid a rent that is not the best rent, and without fine, and the agreement is less than 3 years, it will most likely be a license agreement. Next, we will talk about the relationship between you and Carlito. Is there a social or domestic relationship between the two of you? If there is one, there will be a presumption that Carlito do not intend to create legal intention. Therefore, a lease could not be formed. In terms of legal capacity, an occupant who no longer fulfills the condition of residency to which the grantor, who had no authority to grant a lease, will be a license. So, if Carlito does not own the land in the first place, he could not grant a lease to you. Therefore, only a license remains. A licensee has very limited rights. A licensee does not have exclusive possession of the land, merely a right to occupy the land. Therefore, if the agreement is a licensee agreement, you will have to allow Carlito to let Franklin to come in and stay in one of the rooms in the house, because as a licensee, you do not have the right to exclude other persons from the land. Next, my fellow agent 9421, would give the conclusion on our findings of your case.
Therefore, it is submitted based on the arguments that Carla is more likely to have a lease as the cause unrestricted access appears like a sham, even though the certainty of the term is uncertain. However, for Carla to have a stronger cause of action, she has to raise the fact that she has control over her premises entirely, paid her rent monthly, and she has the intention of having a matrimonial home. The only issue is whether Carla has registered her lease. Assuming if Carla has registered her equitable lease as explained by my fellow agent, her lease would be binding on Carlito and she could exert her right as a tenant to sue for nuisance or trespass if the landlord insisted to let his friend stay with her. If Carla has not registered her equitable lease, either under registered or unregistered land, Carla's right would not be binding. However, if Carla's lease is less than 3 years, there is no need to register the lease as she has a parent lease and her rights are binding under Section 54, Clause 2, LPA 1925. Thank you.